Good evening, everyone. So, yesterday, after the judgment given by Supreme Court, the moot question before us: does the governor enjoy any discretionary power when it comes to assenting the bill? Can governor use his discretion in order to push any bill, in order to keep any bill for an indefinite period without taking any action? Does governor enjoy any veto power? Does governor have some sort of pocket veto when it comes to, passage of bill, when it comes to assenting of bill? This is what we are going to discuss. Good evening, everyone. Good evening, Prince. Good evening, everyone. So let's start the session. Try to understand. We will try to unravel every single minor detail. We would try to understand what Supreme Court has done in this particular case, that is the state of Tamil Nadu versus governor, Tamil Nadu governor case. ठीक है, तो देखेंगे. We would also try to understand how Supreme Court over a period of time rein in the power of governor. We will see Shamsher Singh case. We will also analyze Rameshwar Prasad Singh case and many other. So let us start and try to understand. First, let us understand the context. Already I told you, this case is the state of Tamil Nadu versus governor of Tamil Nadu. Here Supreme Court has restricted the power of governor. Supreme Court said whatever actually R.N. Ravi did, that was unconstitutional, that was illegal and erroneous in law. So let us understand what is the issue. पूरा का पूरा पहले context समझेंगे and first we'll try to understand content, what we are going to read. First thing is, what are the key issues that were before the Supreme Court bench? Supreme Court bench के सामने issues क्या थे? When the case came in front of the Supreme Court bench, so what were the issues that were identified? Second is, what is Article 200? Article 200, does it give any general discretionary power or not? Third is salient aspect of this judgment. What has been, good evening Krishna, what has been highlighted by Supreme Court judgment? Previous rulings related to, powers of the governor. Previous rulings when Supreme Court has tried to curb the discretionary power of the governor, that also we would try to understand. Still, despite this judgment, what are those gray areas where still there is scope for contestation between governor and elected government? This is what also we are going to see, and what happens now to similar cases by other courts and then way forward. So let us understand, these were the four issues that was in front of the Supreme Court when the case was listed. First important issue is कि can governor keep the bill pending for indefinite period? एक बिल गवर्नर के पास जाता है, क्या वो उसको indefinite period के लिए पेंडिंग में रख सकता है कि ना रख सकता है? That was the first question, that was the first issue. That was the second important issue is, under Article 200, is the governor obligated to resend a bill to the Legislative Assembly with reasoning, or can he simply say that I withhold my assent? अगर आप assent को withhold कर रहे हो, so are you supposed to provide reasons also or not? Okay, that was the second issue. Third issue was, can, अभी governor क्या किए थे? This was a peculiar case. Tamil Nadu was a peculiar case. In the first instance, when the bill was sent to the governor decided to withhold his assent. So later on, once again, assembly passed the bill and send it to governor. Governor, instead of withholding or taking any action, governor kept it for sending it back to the president. So this was a peculiar issue. अब यहाँ पे Supreme Court को ये देखना था कि when can the governor send a repassed bill which he has already withheld assent from to the president for assent? Can he do that or not? And fourth important question was कि whatever Ravi did over there in Tamil Nadu, was it unconstitutional or not? Should he confine, or should the Supreme Court try to restrict the overall discretionary power enjoyed by the governor or not? So these were the major issues that was in front of the Supreme Court. Now let us understand what is Article 200. Generally समझना, दो article are very much important when it comes to general power of governor. One is 163, another is 174. I'm not going to discuss 174 over here. 163 gives general power to the governor. But when it comes to assenting of bill, Article 200 is very much important. अब समझो कि Article 200 है क्या? Article 200 is related to basically when a bill is passed by the legislature of a state and it is presented to the governor has generally four options that has already been provided in Article 200. पहला ऑप्शन ये है कि he can give his assent, done. Second option है he may withhold his assent. Third option है he may return the bill for reconsideration. And fourth option है reserve the bill for the consideration of the president. He may reserve the bill for the consideration of the president. These are the four options. No, there was no time limit. In fact, यही तो इशू था. Article 200 itself says मजहर. अब ये समझो क्या लिखा हुआ है. Article 200 में there is a key proviso that says that governors may as soon as possible, the term is as soon as possible, return bill other than money bill with a message requesting that the house reconsider in its parts or in whole. If the legislative house after reconsidering the bill sends it back to the governor shall not withhold assent therefrom. यहाँ पे term is operative term is as soon as possible. Nowhere time limit has been imposed, nowhere time was defined. Okay, so this was the issue. अब governor was taking advantage of this proviso only. इसी proviso का वो use कर रहे थे. After withholding assent, he was keeping the bill with himself without sending that bill for reconsideration or without showing any reservation. आपको बताना होगा ना कि what are the reason why you are withholding the assent. So while the governor must return the bill as soon as possible, no time frame was given. Raj Bhavan have exploited this ambiguity to sit on bill indefinitely without returning them to the state legislature. This was the major issue. अब इसी को लेकर contestation था and Tamil Nadu government decided to approach to Supreme Court. Now see what the Supreme Court said. Supreme Court का जो judgment है that can be divided into four part. First part में Supreme Court ने बोला governor does not enjoy any veto power. Governor has no veto power under Article 200. जब वहां पे operative term is as soon as possible, देखो क्या बोल रहे हैं गवर्नर कि whenever a bill is presented to the governor, he is under the constitutional obligation to take all the four actions that have been prescribed by the constitution. Second important thing Supreme Court ने ये बोला कि the expression as soon as possible का मतलब क्या है? You need to be expedient. जल्दबाजी में आपको उसको पास करना है क्योंकि government of the day represent the mandate of the people. Understood? So as soon as possible you need to show some sense of expediency and governor cannot withhold assent in a summary manner. आप बिना कोई रीजन दिए हुए एक इलेक्टेड गवर्नमेंट का विश को ऐसे ही आप रिजेक्ट नहीं कर सकते हो. So that is the first important thing. Second salient aspect of this judgment is top court fixes timeline for governor. This is the most revolutionary case. Like in 2025 ये अभी तक का सबसे revolutionary case है. Let me tell you one thing. What Supreme Court did. Now whenever any bill would be presented to governor, now governor has a maximum of 1 month to withhold assent on the aid and advice of the state cabinet. एक महीने के अंदर उनको बताना है कि whether he is giving assent or he is withholding assent. Suppose governor has decided to withhold his assent, तो जिस दिन से उसने बताया कम्युनिकेट किया है काउंसिल ऑफ मिनिस्टर्स को, उसके बाद 3 महीने के अंदर governor must specify the reason and with that reason ask the state legislative assembly to reconsider the bill. देखो क्या लिखा हुआ है. If he withholds assent contrary to the cabinet advice, he has a maximum of 3 months to return the bill with a message specifying his reasons. Okay. Third important thing, the governor has 3 months to reserve a bill for president's consideration against the advice of the state cabinet. Now, if governor wants to reserve a bill for president consideration, तो वहां पे भी maximum time limit has been imposed, that is 3 months. And fourth important thing is the governor must, यहां पे use क्या है, must grant assent to a bill that has been repassed by the state legislative under article 200 within a maximum of 1 month. यहां से withhold assent किया, उसके बाद अगर स्टेट लेजिस्लेटिव असेंबली में दोबारा बिल गया है, अगेन हाउस हैज पास्ड इट, तो उस केस में गवर्नर नीड टू गिव एसेंट विदिन 1 मंथ. थर्ड इंपॉर्टेंट aspect of this judgment was, can the governor reserve a bill for the president's consideration which was earlier rejected by him. अभी क्या कर रखी है गवर्नर इस केस में, स्पेसिफिकली तमिलनाडु में. A bill was sent, he withhold his assent. उस एसेंट को विथहोल्ड करने के बाद हाउस हैज रीपास्ड दैट बिल. तो अब गवर्नर ने क्या किया, इंस्टेड ऑफ विथहोल्डिंग और डूइंग, क्योंकि नाउ गवर्नर इज बाउंड टू गिव हिज एसेंट, सो ही सेड ही इज रिजर्विंग दैट बिल फॉर रिकंसिडरेशन बाय प्रेसिडेंट. सुप्रीम कोर्ट ने इस इश्यू को भी देखा, सुप्रीम कोर्ट ने बोला नो, गवर्नर कैन नॉट डू दैट. क्या बोल रहे हैं सुप्रीम कोर्ट, गवर्नर कैन नॉट रिजर्व अ बिल फॉर प्रेसिडेंट्स कंसिडरेशन व्हेन द प्रपोज्ड लॉ व्हिच वाज अर्लियर रिजेक्टेड बाय हिम is presented for the second time by the state legislature. If you wanted to keep it for the presidential consideration, you should have done it in the very first instance. Okay, this is what Supreme Court said, ki reserve the bill for the consideration of the president, he ought to have done it in the first instance. So decision of the Tamil Nadu governor was not bona fide, rather it was malafide. Okay, this was the third important aspect of judgment. And fourth important aspect of judgment was use of article 142. Total 10 bills were sent to president for presidential reconsideration. Supreme Court using article 142 said all those bills are deemed to be assented. इसका मतलब all those bills have become now act. चाहे वो प्रेसिडेंट का कंसिडरेशन मिला हो या ना मिला हो. 10 बिल में एक को प्रेसिडेंट ने कंसिडरेशन दे दिया था, 7 को रिजेक्ट कर दिया था, लेकिन सुप्रीम कोर्ट ने सबको बदल दिया. यूजिंग आर्टिकल 142 सुप्रीम कोर्ट सेड ऑल दोज बिल्स आर डीम्ड टू बी पास्ड नाउ बिकॉज the 10 bills as having received assent given the unduly long period of time for these bills were kept pending by the governor before the ultimate declaration of withholding of assent. So all those bills have been deemed to be now become law. ठीक है, so these are the 4 important aspects. Next important thing is, next important part of this lecture is कि what are the previous cases that have dealt with the power of governor, that have tried to curb the power of governor, rein in the power of governor. और उसमें सबसे इंपॉर्टेंट केसेस शमशेर सिंह वर्सेस स्टेट ऑफ पंजाब 1974. इस केस में सुप्रीम कोर्ट स्टेटेड दैट द गवर्नर इज बाउंड बाय द एड एंड एडवाइस ऑफ काउंसिल ऑफ मिनिस्टर एज अ रूल एंड कैन only exercise discretionary power as an exception. मतलब they can use discretionary power only in some exceptional circumstances, otherwise they are bound by the aid and advice of the council of minister. सेकेंड इंपॉर्टेंट केस है, इसके अलावा भी एक इंपॉर्टेंट केस है हरगोविंद पंत वर्सेस रघुकुल तिलक केस, मैं वो हाईलाइट नहीं कर रहा हूं. कमिंग टू नेक्स्ट केस, रामेश्वर प्रसाद वर्सेस यूनियन ऑफ इंडिया केस 2006. सुप्रीम कोर्ट ने इस केस में क्या बोला कि इंडिविजुअल ओपिनियन ऑफ द गवर्नर कैन नॉट बी अ ग्राउंड फॉर इंपोजिंग प्रेसिडेंट रूल. ये बिहार का केस है. इस केस में सुप्रीम कोर्ट ने यह बोला था कि इंडिविजुअल ओपिनियन ऑफ द गवर्नर, अगर गवर्नर को अकेले ये लगता है दैट प्रेसिडेंट रूल शुड बी इंपोज्ड, सो दैट कैन नॉट बी अ ग्राउंड फॉर इंपोजिशन ऑफ president rule. Another important case is Nawam Rabia and Bamang Felix versus Deputy Speaker, which is also called as famously called as अरुणाचल प्रदेश असेंबली केस. 2016 का केस है. सुप्रीम कोर्ट ने यहां पे क्या बोला, दैट द पावर टू समन द हाउस इज नॉट सोली वेस्टेड इन द गवर्नर. मतलब व्हेन हाउस इज इन सेशन, उस केस में even a speaker can call the session, not only governor has the authority to call the session. Next important case जो है, ये पिछले साल का केस है, 23 का, not 24 का. The state of Punjab versus principal secretary to the governor 2023. इस केस में सुप्रीम कोर्ट ने क्या बोला कि गवर्नर इज अ सिंबॉलिक हेड and cannot withhold action on bills passed by the state legislature. ठीक है, गवर्नर एक सिर्फ सिंबॉलिक हेड है एंड ही कैन नॉट विथहोल्ड एक्शन ऑन बिल्स पास्ड बाय स्टेट लेजिस्लेचर. वंस द स्टेट लेजिस्लेचर हैज पास्ड सम बिल, सो ही कैन नॉट विथहोल्ड एक्शन. उसमें कोई एक्शन ऐसा नहीं है कि आप वीटो को एंजॉय करेंगे. तो बेसिकली दिस जजमेंट इज एन एक्सटेंशन ऑफ द स्टेट ऑफ पंजाब वर्सेस प्रिंसिपल सेक्रेटरी टू द गवर्नर केस. ठीक है, नेक्स्ट इंपॉर्टेंट इज ग्रे एरिया वेयर the role of governor is likely to be judicially scrutinized. Okay, yes बाबू ऋत्विक, जब मैं ये बार बार क्लास में बोला हूं, तुम नहीं किए हो आईपीजी का क्लास, आई हैव ऑलवेज सेड आर्टिकल 142 is extraordinary power. It equips Supreme Court with extraordinary power. Supreme Court, in order to achieve complete justice, can do anything, including changing the decisions of president, changing the decision of anybody of this country. ठीक है, so article 142 is an extraordinary power. ठीक है, so next important thing is gray area where the role of the governor is likely to be judicially scrutinized. अभी भी कुछ एरियाज हैं जहां पे there can be contestation between council of ministers means cabinet and governor. एक तो है that is the power to grant sanction for constitution against a state government official. अभी देखिए, मुद्दा केस में सिद्धारमैया के खिलाफ ग्रांट सैंक्शन किए थे वहां के गवर्नर ना. सो दिस इज अनदर इंपॉर्टेंट क्वेश्चन, वेदर गवर्नर एंजॉय द पावर टू ग्रांट सैंक्शन फॉर कमीशन. कुछ यहां पे इट वाज नॉट कॉन्स्टिट्यूशन अगेंस्ट अ स्टेट गवर्नमेंट ऑफिशियल. तो दिस इज अनदर इंपॉर्टेंट केस लाइंग विद द गवर्नर. सेकेंड इंपॉर्टेंट इज द पावर टू इनवाइट पॉलिटिकल पार्टीज टू फॉर्म अ गवर्नमेंट. कैन गवर्नर invite any political parties who is not even enjoying majority? Okay, so this is another important moot question. These are the two gray areas jahan pe Supreme Court needs to clarify its position more clearly. Though पुंछी कमीशन इस मामले को अच्छे से डील किया है, but governor is still not following those. ठीक है, so what happens now to similar cases by other states? जो तमिलनाडु का केस है वैसा ही केसेस केरला का भी है, वैसा ही केस तेलंगाना का भी है, बट दीज आर लिस्टेड बिफोर सम अदर बेंचेस. तो हो सकता है कि नाउ सुप्रीम कोर्ट वुड ऑल्सो प्रोवाइड रिलीफ टू बोथ ऑफ दीज स्टेट्स. इनका भी जो बिल्स हैं दोज वुड बी डीम्ड टू बी पास्ड. ठीक है, नेक्स्ट इंपॉर्टेंट थिंग इज व्हाट इज द वे फॉरवर्ड. Try to keep one thing in your mind कि governor is a constitutional position, so he or she must exercise his power in good faith and to uphold constitutionalism. Ultimately, you are the conscience keeper. You are the constitutional means you are the one who uphold the constitutional value in the state. Are you getting? So that thing governor always keep in his mind. Next important thing is governor must follow Punchi Commission advice that governor does not enjoy any discretionary power, because the use of discretionary power goes against the very ethos of constitutionalism and rule of law. So these are the way forward. I hope I have made everything clear. This you can get the PDF of this lecture on my Telegram channel, UPSC with Deepak Prakash, and this is important for pre, mains, GS2 as well as PSIR, those whose optional is political science, उनके लिए भी इंपॉर्टेंट है, GS2 में भी इंपॉर्टेंट है, as well as pre. So मेक अ नोट आउट ऑफ इट. यहां से जो भी नोट्स आप करेंगे अच्छे से उसका नोट्स बना लीजिए. दिस इज गोइंग टू बी रियली इंपॉर्टेंट. बाय बाय, सी यू टुमारो. बाय बाय, टेक केयर.